Number 47, People ex rel. Rivera versus Superintendent.
Good afternoon, Your Honors. Kerry Elgarten for Mr. Rivera. I'd like to reserve 2 minutes for rebuttal.
Yep, give your co-counsel and adversary a second to sit down.
Sorry.
Go ahead.
Subjecting Mr. Rivera to the cumulative effects of Sora and Sarah for a crime that he committed in 1986. I think I need some water. So subjecting him to Sora and Sarah violates the ex post facto clause. His crime was committed before either of those statutes existed, and the Supreme Court has prescribed a way to analyze the situation where the law that's in effect is denominated as regulatory, but it has an impact on the person after their crime was committed. And it's the intent effect test. And that was in Smith v. Doe. And they did it in exactly this kind of a scenario, and analyzing a sex offender registration scheme. In that case, they found that there was no ex post facto violation, but they noted very specifically that one of the main concerns was whether there was affirmative restraints. And they said there were none. It was really just an informational registration and notification. Here, New York had SORA. All of those impacts built over time, even though, again, the crime was committed before SORA even existed, before there was even such a thing as a sex offender. And then when Sarah came about and was then amended, the residency restriction came into play. And under that residency restriction, Mr. Rivera and hundreds of other people are not just banished from society into shelters, but they wind up in being detained, having their incarceration extended.
And what's the effect of the parole conditions before Sarah that imposed some residency requirements? Does that change your analysis at all?
No. So prior to Sarah, the Division of Parole was authorized to impose residency restrictions based on what they considered to be appropriate. What makes this an ex post facto violation, and what ex post facto prohibits, is the enactment of laws. Congress shall make no ex post facto laws. So previously, there was authority and rarely exercised, I'll say as well, that I don't think we're going to find situations where sex offenders prior to Sarah were restricted from. In fact, even after Sarah was enacted, those provisions were not imposed. And it was only later, about 2014.
I'm not sure I understand the distinction. If a restriction is imposed on a parolee by operation of law, as opposed to being imposed by a Department of Probation or a judge or something like that, what about that makes it ex post facto? Is it just the fact that it comes from a statute?
It's largely that it comes from the statute and that it's mandatory. So everybody in these categories, from Mr. Rivera, that he's a...
But if it's imposed by some other source, it's still mandatory. If you violate the term of the probation, you're still going to be subject to the same sorts of punishments that you would be if you violated a restriction that was imposed by statute, wouldn't you?
Right, but the restriction here is imposed by law.
But it's not in your case, is it? I mean, it could be if you commit a certain crime against a minor, but as I understand your client, it's possible he'll have this condition, but it has to go through a SORA court to adjudicate him a level 3. And the SORA court looks at a number of different factors outlined in the RAI, and ultimately will make a determination of what level that person is at in this case, a decision was made of a level 3, but the SOAR court also has discretion, even if the points add up to level 3, to go to a 2, which wouldn't put you in this category. So to me, this seems then more analogous to a probation officer who can look at this case and say, yeah, I'm going to put a residency restriction in because the SOAR court is looking at different risk factors, including the crime, but other things as well, and the for and against the departure argument, and then making the determination, which then gets you the condition. So I think the argument you're making would be stronger, wouldn't it, if this was a case where it was mandatory under the statute, but it's not.
Well, it's mandatory under the statute once the level 3 determination is made.
So is a parole condition mandatory under the
No,
parole
no.
statute once they put it in and it's exercised in
No, it's not mandatory. A parole condition is not mandatory. A parole condition to stay away from a certain
But by
neighborhood
virtue of
is-
your conviction of your client, the SARA condition is not mandatory. It's not.
The Department of Corrections' position here, docs, is that they have to impose this.
They have to once there's a determination made that your client's a level 3. But by
Correct.
virtue of his conviction, unlike, say, conviction of a
Correct.
crime against a minor, he's not subject to SARA. He's not subject to SARA until a court determines that he's a level 3 offender. So it's not a condition imposed because of his conviction.
It's a condition imposed because of his level 3 adjudication upon his conviction and the mandatory process, excuse me, that's involved with the SARA adjudication. Whereas a parole condition is just, first of all, we included some cases in our reply. Here, everybody who's a adjudicated level 3 will automatically be subjected to the residency restriction.
Everyone convicted of the crime your client was convicted of is not a level 3 by operation
Correct.
of law. So it's not a function of his conviction, it's a
But
function of the
if he
determination
didn't have the
of the SOAR
conviction,
court.
well, if he has because of the conviction, he has to have the SORA hearing, because at the result of the SORA hearing, he is a level 3 offender in this case, and as a result of that, the executive law mandates that he be given this condition.
Counsel, with respect to your analysis of excessiveness, you cite a number of cases in other jurisdictions that have found an ex post facto violation, right? But I'm not sure what we can make of those. You are required to show clear proof that the effect is punitive if the intent is not punitive, right? And are you asking us to somehow take judicial notice of those cases? I'm trying to understand where you think the evidence is that the condition is in fact excessive.
In those cases, there's in most of them, not all of them, most of them, even some which don't have a residency restriction, they were found to be punitive and excessive.
Right, but that's in the context of those courts looking at studies and data with respect to particular statutory regimes. And I'm not sure whether we have that in front of us. So how are we to answer the
Here,
excessiveness
the result
question?
of the residence restriction is the paradigmatic punishment of imprisonment. Mr. Rivera was kept in prison for 2 extra years
Well, there
because...
it seems to me you're making, correct me if I'm wrong, 2 sort of different arguments about when you're looking at the effect end of, and I think we can agree we're dispensing with the intent end, right? We're just talking about
Yes.
effect. So in effect, it seems to me you're making 2 different arguments in parallel. I don't think they're inconsistent. One is that Sarah applied retroactively to everybody whose conviction occurred before Sarah was enacted. We could even say before Sora and Sarah were enacted, doesn't matter, is subject to an unlawful ex post facto law. That's your broader claim. And your narrower claim, as I understand it, is that anybody who, as a consequence, who again, was convicted before Sarah Sora, who as a consequence ends up being incarcerated for a point past the other, what otherwise would have been the release date because of the operation of SARA is suffering from an unlawful ex post facto law. Do I understand those correctly?
So the first part, yes. And anybody who committed their crime before SORA or SARA went into effect is automatically being subjected to punitive effects that amount to a violation of ex post facto.
Some of those people, let's say particularly people upstate, are released when they're supposed to be released, and even if there's a restriction, it doesn't really bite on them, right? I mean, it's not the case that everybody who is subject to SARA can't immediately find compliant housing.
Right. My position is that Mr. Rivera, I mean, the case is about Mr. Rivera's finding below, by the judge below, that ex post facto was
But
violated.
this is not an as-applied challenge, is it? I mean, you can't really do an as-applied challenge for this kind of case, can you?
Well, every ex post facto is as applied to a person prior to a certain amount of time.
But the Supreme Court has said in Selling, I think, that we
Right.
can't consider it on a individual by individual basis, because that
Right.
keeps us from deciding whether the statute is punitive. So I'm not sure how.
Right, but when they're talking about individual basis, they're talking about idiosyncratic effects. If we look at the way cases have applied it, here we're talking about the broad impact on hundreds of people that they are, as a result of the residence restriction, are kept incarcerated for extra amount of time.
That's what I'm
in this case,
characterizing
2
as your
years.
narrower argument, right? Which is that you have a broader ex post facto claim about everybody who's released and can't find, well, some of them can find housing, but you have a narrower claim as to people who, as a result of the SARA restriction, are kept in prison. And so when we get to the question of whether something has a punitive effect, at least it seems to me you have however weak or strong your arguments are, you have a stronger argument as to the people who are kept in prison than you do as to the broader class of people. Some of whom are not kept in prison.
I agree. But the fact of the matter for Mr. Rivera is that his crime preceded SORA. So if somebody's crime preceded SARA, but SORA was already in effect, then we would have to discount any of the impact of SORA, which, as I said, as I
But he's not challenging his registration status here. I mean, right, the way that SORA matters is only that it's the hook to get him into SARA, for your purposes.
I don't agree with that. But I would say clearly the largest impact, the greatest, most obvious punitive effect is the registration restriction, which comes about under SARA and resulted from Mr. Rivera and many others in their incarceration.
I'm having a little bit of difficulty conceptualizing the nature of the punishment. When you do a standard intent effects test, the effects part, we're looking at the restriction and we're deciding whether it's really more punitive in nature or whether it relates to some legitimate regulatory, non-punitive purpose. And I don't have any trouble understanding that we need to do the analysis with respect to a residency restriction to determine whether it's punitive in nature or serves a legitimate purpose. But there's nothing in SARA that says a person shall remain incarcerated. That to me seems to be just a consequence of the fact that you cannot meet whatever the restrictions are that have been placed on you. So do we have to hold SARA accountable for the fact that someone gets held back in a facility? Does that count against the regulatory regime?
Yes, so we look at the likely and foreseeable consequences. The as-applied analysis disallows some, unique consequence for a particular individual. Here, this court has approved the idea of people being detained beyond their otherwise release date. So and there's hundreds of people to whom that applies. It's a foreseeable and likely and common result. And so it is something that has to be
But as
addressed.
Judge Wilson-
Does have to be contemplated in looking at the effects of this law.
As Chief Judge Wilson mentioned, there are a large number of people, maybe even the majority of people, who don't have that impact. They're not forced to stay behind in a facility because they have no trouble finding SARA-compliant housing. So
I think that's a small number, actually, but
I don't know. I really don't know where they're coming from. But the fact that there are those who don't have that problem, does that not sort of speak to the fact that it's not coming from the statute itself?
no, no. So an effect doesn't have to be considered an effect under the intent effects test. An effect doesn't have to be universal. It doesn't have to apply to every single person. It has to apply to many people. It has to be common and foreseeable. And that's the way all the Supreme Court talked about it, and that's the way the various other jurisdictions talk about it.
Doesn't this fall arguably within what the Supreme Court has described, at least in the concurrence in Selling, as harsh executive implementation? That's the challenge, right? It's not required by the statute, but the way the executive branch is implementing it results in that detention you're talking about, and you can challenge that, and that has been challenged, and that challenge has been rejected. So it seems like you're tagging on the implementation piece that we found is okay to say that's part of the statute. And I think maybe that's what Judge Kennedy.
Well, it's not part of the statute. It's the effect of the statute, because certainly
It's the way the
if
executive
this
is
court had
implementing the statute, right? The executive could decide, not to release to here, but they could send them to someplace else upstate, but they could do a lot of different things. They chose to do that in order to avoid having to release somebody in violation of the terms of SARA. But it's a choice that the
Right.
prison is making, not that's required by the
The
statute.
choice that DOCS is making, that this court has approved, that has been approved, that makes it an effect, that makes that imprisonment, that prolonged imprisonment, an effect of
Well, the effect
SARA.
is to prolong the imprisonment, but it's not necessarily
Well,
a
if-
natural effect for ex post facto purposes of the statute.
But it is exactly, the courts that analyze, that engage in the intense effect test, look exactly to those kind of things. What is the impact on, not this particular person who had lost his job after 2 days' notice, but whole classes of people, large amounts, and not everybody's ever going to be suffering from the same kind of effects. But
Counsel, are there really cases that talk about this extended, because I've read a number of intent/effect cases where they talk about residency restrictions, but my recollection is that the person doesn't have the ability to live around their support structure. They can't be with their family because their family is in a location that's, exempted under the residency restriction. And that all makes perfect sense to me. I don't specifically recall any case getting into an extended discussion about remaining incarcerated while you're having trouble finding residency restriction compliant housing. Is that really a dynamic in the case law?
no, I think that's what's distinct about New York's statutory scheme and the effects of New York's statutory scheme, is that people do, in fact, remain in prison. The ultimate punishment, the paradigmatic, the quintessential punishment as a result. In addition to those the effects of the residence restriction that you're referring to, where people can't live where they want to live. And here, the effect is even more extreme, that somebody actually remains incarcerated.
Thank you, counsel.
Good afternoon. May it please the court. It's undisputed that the legislature intended the school grounds condition to be a civil regulation to manage the risk of harm posed by high-risk sex offenders when they're on supervised release serving a sentence in the community. This civil intent is evident from the text and the legislative history, and this court implied as much in Johnson. SARA made mandatory what the parole board, that is, always had the discretion to do, that is, condition release upon appropriate housing in the community. rational conditions on residency have never been found to be considered punishment, even when those restrictions temporarily prolong detention past an eligible release date. Because any liberty interest a person serving a sentence while on supervised release is always subject to meeting a rational residency
Is it your
condition.
argument that just because it's mandatory doesn't make it improper?
Yes, Your Honor. The fact that Sarah now makes this specific residency condition mandatory, even though the board always had the power to do it, the fact that it's now mandatory with regard to a larger defined set of high-risk sex offenders does not transform this rational parole condition into punishment. It is true that in the past, for this petitioner and others who have...
But keeping individuals incarcerated, that is the quintessential punishment.
Well, Your Honor, I was going to say that it's true that in the past, at least, for this petitioner and for others, who are trying to find housing in the densely populated New York City area, that Sarah has had an unintended consequences of prolonging their release. But that consequence, that unintended consequence, is something that fluctuates over time, and it cannot be the basis for granting an ex post facto challenge, which is necessarily a facial challenge. And
So
as an example of the
Let me ask you a hypothetical. Suppose, so Mr. Rivera he in fact was sentenced to 20 to life, right? So suppose that 10 years after he's sentenced, the legislature passes a law that says that anybody who's sentenced to 20 to life has to serve a minimum of 40 to life. That's ex post facto?
That would be classic ex post facto.
Even though the parole board could have kept him in for 40.
If they're changing the terms of his sentence, the minimum terms of his sentence, say it was a 20-year minimum, and you're making it a 30 or 40-year minimum, that's classically increasing his sentence. That would be a classic ex post
here,
facto.
Part of the argument that I'm hearing is it's okay to keep Mr. Rivera in as a result of Sarah because the parole board could have kept him in for longer anyway.
No, that's not what I'm trying to say, Your Honor.
Okay.
First of all, I just wanted to get out that the changing circumstances with respect to finding Sarah compliant housing in New York City. The DOCS, the Department of Correctional Services, has a working agreement with the New York City Department of Homeless Services to place 12 people in the city on a monthly basis. Two of those
You
people
don't suggest that that means that there is no one who is incarcerated because they can't find Sarah-compliant housing at any given time, I don't
No,
think.
what I wanted to point out was that, and it's been I believe even referenced here today, or certainly by Counselor, that there's been a reference to cases like in 2019 where people said there were like 300 people who were held back from finding Sarah-compliant housing. I can report, at least as of right now, as of May 1st, there's no bottleneck for people who need purely Sarah-compliant housing for New York City. As of May 1st, there were approximately 46 people either in an RTF or at DOCS waiting for New York City Sarah-compliant housing. But of those 46, the overwhelming majority of people who couldn't be placed in Sarah-compliant housing because they had other needs. They needed to be in a nursing home or because they had detainers from ICE or other jurisdictions. So in fact, as of May 1st, although there were 12 beds available, made available to DOCS from New York City DHS, DOCS was only able to fill five of those beds because the remaining people who needed Sarah-compliant housing, don't qualify. There are other things holding them back.
So if the court agreed on the ex post facto argument, it really wouldn't destabilize DOCS, wouldn't have that kind of a big impact, something you could easily deal with?
I think this shows.
It's not like you're opening the doors of 10,000 people. That's what you've just said, that it's only double digits.
If the court found it an ex post facto law,
Wouldn't it only apply to the 46 people you're talking about? And
well, it
perhaps
wouldn't necessarily
not because they have
apply to
other
them at
needs?
all. It would only apply to people who were convicted before 2005.
Well, I thought that these were the numbers you were trying to compare. Perhaps I've misunderstood your argument. Because then I don't understand what you're referring to. If you don't think it has relevance to his argument, why?
Let me take another stab at it, Your Honor. So, in 2019, this court made reference to, I believe it was Your Honor's dissent, actually, that there were 295 people who were being held back from housing past their release dates. And what I'm suggesting to the court, or telling the court, is that as of May 1st, there were 46 people who needed SARA-compliant housing, but of those 46, the majority, we're talking about New York City,
Right, and
of those 46, the majority had other things that were holding them up from finding that SARA-compliant
What
housing.
you're saying is when we look at the effect presently of Sarah, there is no carceral effect of it now, is what you're saying. And if we reduced your 46 by the number of people who couldn't be released anyway for other reasons, and then we further somehow reduce that number based on the people who were convicted before the enactment of SORA and SARA, there might actually be nothing.
I don't know what the numbers are of people
very,
who
very
are subject to
small
SARA whose convictions predated 2005. That's not in this record.
Right, but, well, neither is, I think, what you just told us.
No, it isn't, but
Right.
I thought the court would want to
Yes.
know that the bottleneck, at least currently,
Right.
But if we
was-
declare this an
was
ex
released.
post facto violation, then it doesn't apply to anyone, whether or not they're waiting for housing in New York City or not. It just wouldn't apply. It's not only, we're not going to declare as an ex post facto problem only for those people convicted before a certain date who also are waiting for housing.
Well,
Right.
I believe the argument is that as an it's ex post facto because it increased the punishment as of 2005.
Right.
For people who were convicted before that time. So
This ruling, if we were to make it, would apply to anyone with that issue, not only the subset of people who can't find housing and are detained longer than their release
Oh,
date.
yes. People, it would apply to people who are living in the community, who were convicted before that time, who haven't had any problem getting housing.
So is your view that we could not find an ex post facto violation only as to those individuals who are incarcerated because they can't find SARA-compliant housing, along the lines of your adversary's argument that that's the quintessential punishment, that it's either everyone convicted prior to 2000 or 2005 or no one? Is that your view?
My answer, I would say that this is a facial challenge, so it would have to be under all circumstances that it could not be constitutional. So to only focus on those people whose detention has been prolonged would be an as-applied challenge, would be inappropriate, because it really ultimately wouldn't answer the question. That would depend on the individual circumstances of people. There could have been people being held for a month, there could be people being held for a year and a half. I mean, it wouldn't definitively resolve the question, as the Supreme Court said in Sealing, of whether or not SARA is an ex post facto law.
Okay, can I ask you the flip question that I asked your adversary about the excessiveness? So your adversary points to some decisions, including from the Sixth Circuit, and a couple of sources, including a Justice Department report, which conclude that residency restrictions have no empirical evidence that support their efficacy. And so in looking at your brief, it seems to me that in response you say, well, the legislature intended for the statute to be civil, and the Supreme Court has allowed broadly for restrictions on sex offenders. I'm wondering if you can point me to any place in your brief where you respond to the empirical evidence point specifically regarding the efficacy of the restrictions.
I don't recall offhand if we responded specifically to the empirical evidence point, but I would say that what those studies show is that there is little support for the efficacy of these kinds of restrictions. But I would say that the absence of support for these kind of restrictions doesn't really mean that they're irrational.
Well, that's not the question. Isn't the question whether it's excessive? I mean, if there is some evidence which suggests they have some ameliorative effect, that would be one thing, but if there is no evidence, then that seems to me relevant to the excessiveness
Well,
inquiry.
okay, Your Honor, there's I'd like to answer that in two ways. One is, with respect to some of the cases from the other jurisdictions, like People versus Betts from Michigan, upon which he relies greatly, that case and many of the cases that he cites are SORA cases. They're pure SORA cases. And in those jurisdictions, the residency restriction was imposed as part of a SORA regime. It applied to people who had completed their sentences, whose liberty interest was very different from those who in New York who are subject to SARA. In New York, people are subject to SARA only while they're on supervised release, only while they're serving a sentence in the community. In the People versus Betts case and the other SORA cases from other jurisdictions cited by counsel, all those cases have a different type of liberty interest. Those are people whose sentences are complete. And that's why those cases have no relevancy to this analysis.
Could you I'm sorry, I didn't mean to interrupt you, but I just wanted, your light is on. I just wanted you to finish your thought about the rationality or lack thereof with respect to the absence of empirical data supporting the efficacy of a residency restriction. Because it really did impress me that your adversary had, frankly, a lot of empirical data suggesting that these restrictions don't serve any legitimate non-punitive purpose, and you don't seem to have any.
Well, honestly, because this court has already held in People versus People ex rel. Johnson, where the court had those studies before it, that this was a rational condition. It was rational that the temporary confinement of sex offenders while on a waiting list for SARA-compliant housing was rationally related to the government's goal.
So that question has been answered as a matter of
All I'm saying is that's a legislative choice. This court recognized as much in Johnson. The court said that the difficulties in obtaining SARA-compliant housing don't sever this rational connection. As far as the empirical studies, the majority cited them, but didn't find them persuasive. And I would suggest that's a legislative choice. The legislature could have made many choices, but this is the tools they choose to restrict access to sex offenders while somebody is serving a sentence in the community. Your Honor, as far as like excessiveness, I wanted to say that this is proportional because it only applies to people who are on supervised release, only people who are serving their sentences in the community. And with respect to someone like petitioner, it applies to someone who a court has already determined is a level 3 sex offender. That is, he poses the highest risk of reoffending. And again, it only applies while they're serving a sentence in the community. And I would like to note that, it's not absolute. This statute also gives a parole officer permission to allow someone subject to this condition to enter a school, to work at a school with a parole officer's permission. So it's tailored to, to be proportional. It's not excessive given the fact that someone's serving a sentence, and there are some exceptions that can be applied in individual circumstances.
Thank you, counsel.
Regarding the notion that this condition terminates at the end of the sentence, that actually supports our position that it's, in fact, part of the sentence, that it's a mandatory condition of release imposed for people who are level 1 or 2 with child victims, or level 3. And it's actually, because the parole conditions are only coextensive with the length of the sentence, it shows that it resembles, and in fact here is part of parole, which is part of punishment, which shows that this is punitive, which shows that it violates ex post facto. Regarding the excessiveness of the condition, we've pointed out studies, growing body of research, jurists that have said and concluded that these restrictions really don't serve the purpose that they're intended to, that there's no evidence that they do that.
Is that our job, though, to look at these studies and analyze them? Shouldn't the legislature actually be conducting hearings and asking for experts and deciding whether the methodology used in these studies is something that can be relied upon? Like, is that really what
I
we
think
should
in
be
the
doing?
context of the previous case, of the Johnson case, due process, substantive due process, that maybe that is the more appropriate thing. But here, we're looking at the punitive effect. And so, and what's prescribed is that we look to see, is the sanction excessive with regard to its purpose? And if we know that it seems to be excessive with regard to its purpose, then it's appropriate for ex post facto consideration, even if this court found it, just accepted it at face value because it had been a legislative decision in Johnson. And as far as excessiveness goes, it's particularly noteworthy here that this rule applies to level 3 offenders, regardless of whether there was a child. This is a child access to protecting children. But Mr. Rivera's crime had nothing to do with children. And so the
But the level
excessiveness is
3
even magnified in that
Level 3
context.
determination by the court is risk to the community, right? That's why you're classified as a level 3. So it seems rational to say if you're that level of a risk to the community, that you're level 3, which is the highest, that this is a reasonable condition, that you can't live near children. If you're at risk of reoffending, the highest risk of reoffending in sex crimes, isn't it rational to say, well, at least we want to put on a condition where you're not going to have access to children?
Well, if the condition worked, if it was effectuating the intent of the legislature to protect children, maybe, but where it's not working at all, or there's no evidence that it's protecting children at all, imposing it on someone who we have no particular reason to believe will have any be any danger to children, to me heightens
And
the
your point, I think
excessiveness.
the distinction you make with Johnson and the substantive due process standard and all is a good one. But the standard here for ex post facto is you bear the burden of showing by the clearest proof that the statutory scheme is so punitive in either purpose or effect as to negate the state's intention. So really your burden to come forward with that level of proof. And I think it's the same argument in response to that was the Johnson argument.
I would say maybe it's a close call based on the restriction alone, the residency restriction, although it's our position that even if people weren't winding up incarcerated as a result, that it would still be an ex post facto violation for someone who committed that crime before Sora or Sarah happened. But I lost my train of thought.
But for the people who wind up incarcerated,
For people, right, but for people who are, that's sort of the tipping point and makes it like obvious and makes it clear by the clearest terms that in fact ex post facto, that there is in fact an ex post facto violation.
thank you, counsel.